The new proposed amendments to the land law that seeks to provide for compulsory acquisition of land for government development projects such as roads and other infrastructure have sparked outrage, with sections of Ugandans now accusing the government of trying to grab their land. The draft proposals, midwifed at the NRM retreat in Chankwanzi in July 2016, seeks to amend the Land Act 1998 to ease government takeover of private land. However, the proposals have generated nationwide debate and jitters alike, with the move being interpreted as a maneuver that would fuel land grabbing and evictions in the country. Tonight, the Lands Minister, Betty Among, is on the spot over the proposed amendments and whether this is the silver bullet to address the bureaucratic tendencies in compensation that stall huge infrastructure and development projects. Also on the show tonight is senior lawyer Peter Mulira and the Vice Chairperson of Uganda Land Alliance, Agnes Kirabo. Honorable Minister, Madam Kirabo, and Senior Counsel Peter Mulira, both of you, all of you, I welcome you. You are on the spot tonight. If I may begin with you, Honorable Minister, in the proposed amendments, what do you want to cure? What do you want to solve?
Thank you very much. First of all, I want to make a correction on your intro, and that already shows that Ugandans lack knowledge on the proposed amendment. The amendment is not new. The amendment is not for compulsory acquisition. The amendment is not on the Land Act. The law related to compulsory acquisition actually first existed in 1900. From the time the first Kabaka gave land, and the British, or at that time, the governor, got power to acquire land for development of infrastructure. And if you look at the 1900 agreement, that agreement gave Kampala, Masaka, Entebbe, and etc. as areas that were given to government for infrastructure development. That's why when you go to Entebbe, you see State House. When you go to Entebbe, a number of government infrastructure like the airport, like a lot of other agricultural institutions, survey and mapping department, actually very many government departments started in Entebbe because of a law that gave the governor part of Entebbe. Actually, Entebbe in general, Kampala was given to the governor under compulsory acquisition for purpose of establishing government infrastructure. That's why Kampala now is a capital city. Now, that was anchored in the 1962 Constitution. After the 1962 Constitution, the 1965 Land Acquisition Act was enacted, and under that law is a very well embedded serious provisions on procedures under which compulsory land acquisition is acquired after the minister appointing an assessor, and all the other negotiation up to when chief government valuer, who in the law is termed as an assessor, gives an award. So this particular law worked very smoothly from 1965 until about 2011, when an NGO went to court in the case where they sued UNRA. That is when government was dealing with the Oima Kaiso Road.
Koisotonya Road.
Exactly. So actually one person who had a problem with the value that was given by government went to court and studied Section 7 of the 1965 Land Acquisition Act. That particular Section 7 gave the Minister of Land, after an award of compensation value, the power to take over land, and when takes over that land in public interest before compensation. Now, in 1995, under Article 26, a principle of compulsory land acquisition was enacted. That principle gave certain conditions. The condition was that compulsory acquisition can only be done or can only be conducted by government for purposes of public use, public safety, public order, public health, public morality, and in the interest of defense. And so those are the conditions given under Article 26 for purpose of
so if there's a contestation, it is only on compensation.
Exactly.
And then an ongoing project.
Exactly. So the current amendment is not new.
Yes.
The current amendment is not on the principle of compulsory acquisition. The current amendment is only on dispute arising out of value awarded by the chief government valuer, and if a person disputes the value that has been assessed by the chief government valuer.
Okay.
What happened?
All right. Before I even bring in somebody from the Uganda Land Alliance and the civil society, let me come to you, senior lawyer, Counsel Peter Mulira, because should we as Ugandans get worried over what is being proposed? Because it's a fact that sometimes you find infrastructure projects delayed because somebody is saying, you have to compensate me. But there seems to have been already a law that gives government powers to take land, compulsory acquisition. Not to grab, compulsory acquisition.
Well, I would say this, that we have a problem here, because the Minister of Lands is a person in whom everybody has confidence. And when she says what she has just said, we tend to believe it. But from a legal point of view, we don't take things for granted. The Minister has talked about the land which was given by the Kabaka to the central government in 1900. That was by agreement, so you cannot put it in the context of acquisition. And that land was returned in under the Constitution of 1962. Actually, it was done under the agreement of 1961, and it was leased back to the government for 99 years at the rent of 1 shilling per year. So that's what we call peppercorn rent. So the idea was to facilitate the government to continue using this land by agreement. But the 1967 Constitution took it over. That was grabbing. And we are still under that situation. And that's why some of us say that if the NRM government came to correct the wrongs of the past, we should really address these issues generally, and not just pick out one item, as has been done, and try to amend the Constitution. And I'm against the Minister's proposal, not on a political front or ground, but for the simple reason that the Constitution is not tampered with piecemeal. Because once you introduce what the Minister is proposing to introduce, you are going to infect, we call it infect, other provisions of the Constitution.
It's already infected anyway.
It's already infected, okay. It's sick. But to be specific, when you introduce the proposal that the Minister is introducing, two things are going to arise. They are going to bring it in what we call the Bill of Rights, under Chapter 4 of the Constitution. The Bill of Rights came about as a result of people winning their rights against the government. Now the government is telling us that it can give itself power which the people did not give it. And that cannot come under the Bill of Rights, because the Bill of Rights specifies the rights of people. Now the bill wants to specify the rights of government. It's not allowed.
Okay. Agnes, from your point of view as Land Alliance, what scares you from this bill?
I think it is not about Uganda Land Alliance or the civil society being scared, but it is about the concern of the people at large. Because one, we are seeing so many processes running parallel to each other, and if we pick up a particular case, like the minister is speaking from Article 26, and then we run for a constitutional amendment, amidst other processes that the government has put in place, where people had hope that maybe these processes are aimed at dealing with the whole land question in its totality, and then come up with the proposals, and these proposals then set the pace at which we are going to deal with the land issues in this country. So at the beginning until now, when we saw government start running after Article 26 in particular, we and the people are concerned. Then what is the commission supposed to do? Because we thought that the commission is coming into play to really open up the issues of land in this country, and then we start looking at them in totality in a holistic manner. So it causes suspicion, but also it causes it questions the commitment that government has to the hefty amount of money we are spending on the commission, and the demonstration that the population had exhibited to giving the commission information vis-a-vis this. But also, we have a feeling, and I think largely Ugandans feel, that the law and the constitution, as it were, is just enough for government to evoke its powers. Because if we on the scale of 1 to 10, how many are of these cases? Who are we legislating? Why are we amending? And not only amending a law, but a mother law. So this spaghetti bowl of things running east, west, and center, I think leaves the people with the space to really to suspect.
Okay, Agnes is raising the issue of the commission that is on. It's a government commission. There's a bill which is also a government bill. Why didn't you, as government, also bring some of these problems that you see, the challenge that you see, before a commission that is ongoing, headed by a judge, and perhaps there you can treat the problems that we see in the Uganda's land question?
Let me first, I am very happy that both do not actually have substantial agreement, a disagreement with me. I am very happy because their argument is based on fear. For us in government, for us in politics, we don't work based on fear. We work based on solving a problem. Let me first answer the issue raised by the senior counsel on the question of the Constitutional Bill of Rights. Already under Article 26, the exceptions have been given. Article 26 says that nobody shall be deprived of a right to property except where the deprivation is for purpose of government acquiring land for public good, for defense, health, public morality, what I had stated. So the same constitution that gave the Bill of Rights is the same constitution that has given government exception under Article 26. Therefore, the argument that this deprives the people of their right does not arise. So that fear, both legally and maybe I am only left together with government to reassure Ugandans, which I have done, that first, the misconception that this is a proposal for compulsory acquisition has now been settled. I am glad all of us on this table understand that. Two, the whole issue of why is it coming under the Constitution? I clearly stated that the 1965 Land Acquisition Act had cured the problem, where Section 7 stated clearly that when the Minister of Lands feels that there are exceptional cases that requires her or him to take possession before compensation, he or she would do that. But that was expunged by both Constitutional Court and Supreme Court 2014. Why? Because 1965 Land Acquisition Act was enacted way back before the Constitution. When the Constitution Article 26 was then enacted, it did not take consideration of that section. And so when this person went to court, the question of prior, which is in Article 26, necessitated removing that power. So that power is what you want now. catered for circumstances which we are facing now, wherein
That's the power you want returned.
the power I want to return. Now, we as government, why the constitutional provision
that you can force on me what the government valuer has assessed, and you put it on my account, continue with your development projects on my land, even though it has not been completed in the courts of law.
Yes, because
that's what you want to be done.
Yes, because one, I want to say this because there are people who misunderstand. The principle of compulsory land acquisition has about 3 principles. The first one is the compulsory acquisition,
yes,
which already exists. The second is condition under which you must acquire, which is fair, adequate, prior compensation. The third principle is the value.
So where
of
is fairness? Where is fairness before court determines?
Now, under the Land Acquisition Act, the power is with the chief government valuer to determine the value. But the chief government valuer doesn't do it alone. The chief government valuer has a process right from section 2 of that act up to 12. It's a process of negotiation with the landowner. It's a process of obtaining land value at that market replacement value.
But Honorable Minister, that's why there's also a court that if somebody thinks a situation is not fair to him, then you can go to court.
Now,
so even if there's a government valuer,
where the proposal
so, but
is,
you want to take possession of the land, even when somebody feels it's unfair, before even a court case is disposed of.
Yes, because the commitment under the proposal is that if you win, whether you win, when you win the case, government will top up. So you don't have injustice. Government will give you prior payment of the value assessed to everybody.
Okay.
Those who dispute and those who don't dispute. Then the bill is saying that the top up you want, we shall pay if court determines, because our hands are tied. Why? Because the Land Acquisition Act says the value determined by the chief government valuer is the value government must pay. And the process of determining that value takes between 3 to 6 months. I do not want the 70% who have consented to suffer. I don't want the money that I have in my coffer to keep accruing idle equipment. So the fact that I have already acquired, the only problem is on the value.
Senior Counsel Peter
all
Mulira,
I want, let me finish. Yes,
you've had
all that government wants is to say we have resolved the issue of acquiring your land. The only dispute is on price. Yes, I will pay you what the law says, and then when you determine what you are disputing, I will top it up. And Parliament, give me a time frame within which this dispute should be resolved. If Parliament tells me within 1 month this dispute should be resolved, so be it. What is unfair there? When I am delivering a public good for you,
that's a question. That's actually the question I wanted to put to Senior Counsel Peter Mulira, whom you actually say that he agrees with you.
He doesn't substantially disagree because it's just fearing that you cannot trust.
No.
Both of them.
No. I think the minister misunderstood me. I think there is a principle here. The minister has quite rightly stated that there should not be compulsory acquisition. That's why she's offering compensation. And these principles are not Ugandan-based. They are international.
Exactly.
Uganda is a subscriber to the United Nations Human Rights Declaration of 1948. Uganda is a member of the African Union, which has a charter on people's rights. And both charters prescribe compulsory acquisition. And the definition of compulsory acquisition is what we have to get here. What does it mean? If the government just says, I'm giving you 10 million shillings for property worth 200 million shillings, you lose it. What we are saying, the present law says that the government acquires the property and my rights are transferred to compensation, monetary compensation. And that is fair enough, because I can refuse the compulsory compensation and go to court to get a better treatment. But what the government is now saying is to say, I'm giving you 10 million shillings, I put it in the court, and that is final.
No.
As far as government is concerned.
She's just adding that should you win a case,
Yes.
you could even get a top-up.
Yes,
But
not
it-
could.
but
Under
that-
the law, it's mandatory.
But at what value?
Proposal.
At what value? Because even at this stage, I'm not preventing you from carrying out your work as the law stands today.
It is
And I want to
stopped.
bring in this point. I think the Agnes brought it up. There's a commission of inquiry going on right now to try and sort out the problems in Uganda land situation today. And what we have today, the minister, I think it was in yesterday's paper, gave evidence of about 7 cases where people have asked made fantastic claims. And all these claims are fraudulent. That's what I fear. They are fraudulent.
How do you reach that conclusion?
Because if you take the land between here and Entebbe, that is Milo land. It has title deeds in MRV system. The people who are raising the objections and making the claims have freehold titles. How can you have a freehold title over Milo land? These are people who went and bought Vivanja holders and went to the land office and got fraudulent title deeds. And we have to sort out that problem first. And that's what the Commission on Land is trying to sort out. And before it comes out with a recommendation, we are saying we are taking over your land. That means that the man who owns Milo land is going to lose out. This is my fear. And I think the minister should take this very seriously. Let her come out with the names, the type of title deeds those people have, the amount of money they are asking for. When I read in the papers the amount which have been mentioned, it is ridiculous.
One of them was about 1.4 billion.
But a road is only
1.3.
40 feet wide. Why should you ask for billions of shillings? The road is only 40.
Has somebody bought a narrow stretch?
Exactly. That's why we have fears. There must be something being
Somebody bought a
hidden from
narrow
us.
stretch to acquire 1.4 billion shillings in one of the compensations.
I am glad,
Because the road is
actually.
going to meander.
I am glad that I'm being understood, I've been sympathized with, and the press published selected evidence. I put over 50 stalled projects across the country, which is here in this paper. In the Albertine region, it's a big problem where oil is passing, the pipelines, the standard gauge railway. I put about 5, national water, electrification somewhere in the north. So by and large, I am glad that we are beginning to understand the problem. But let me address the question of the current law. No, the current law, like senior counsel has tried to state, does not address, because the current law says prior payment before taking of possession.
Mm-hmm.
And for me, I want that possession.
Before you pay.
No, I want that possession when, under the law, the chief government valuer has valued. I pay you, and by the way, the policy under our resettlement program now says you can't return a value to the minister as a chief government valuer when less than 70% have not consented. Therefore, any value that will be returned will be valued that has been accepted by 70+% of the project affected persons. So, what I want, when this value has been determined and brought by the chief government value, which under the policy would have meant over 70% have consented, then those who have objected, whether 30%, whether 1%, whether 5%, government shall then deposit your money in court, and you can access it and anytime you want, but then you go to court
Okay.
for the top-up.
Can I give you information? Can I give you information?
Can I answer the Commission of Inquiry issue?
We'll get
or
into
later?
Later.
Okay.
Agnes,
I want to give you information.
Mm-hmm.
Section 7 of the Land Acquisition Act says specifically that as soon as the assessor gives his award, the property vests in the government, and the right of the owner of the property is converted into a claim to compensation.
That's
And
the one which was expunged.
Yeah, because there you do not pay prompt payment. You don't make prompt payment. Now you want to say that government will decide to put the money in the bank and get around that problem. You can't.
And Agnes, how we need infrastructure development,
Sure.
and that infrastructure will go through maybe private people's land.
Sure.
And there's a catch-22 there. So how do we get what we need as a development projects, but also, you know, and then people stay with their land?
I'm still convinced that, one, Honorable Minister, we are not understanding this issue from here now. We have been understanding this issue. And it is also not fair to say government works to solve problems and you're not going to work on fears. The problems government is trying to solve is solving them not for it alone, but for the people that vested the powers in them. And therefore, listening to people's concerns, I think, is also paramount, other than saying we are going to proceed so long as we are solving a problem, we are not going to deal with fears. I find that quite very unfair. Then two, Honorable Minister, we appreciate and we hear you, but I still insist that we may create a problem while we are struggling to solve a problem.
Which problem?
Your sector that you're dealing with, Honorable Minister, I think is topping fraudsters. It is topping issues that entangled into each other. And these issues, if you turn and really try to understand, there's so many cases that you said you profiled, so many of them, and media selected, I don't know the criteria of those that they were able to publish, maybe others are coming out tomorrow. I think we need to do a thorough problem analysis.
Hold on to your point there, because we're going to take a break. When we come back, I also want to put to the Honorable Minister that I've seen roads that have taken forever. For example, Tororo Mbale Road. And there was no compensation, I suppose, because that was an old road. But it took a lot of time. Another example is Kamuli Ginger. There was no compensation. The road took forever. Sometimes these delays are not about compensation. There are other inefficiencies in government that need to be sorted. We'll be right back. Welcome back. You're watching On The Spot. My name is Patrick Kamara, and my guests tonight are Senior Counsel Peter Mlira, Vice Chairperson of Uganda Land Alliance, Agnes Kirabo, and Honorable Betty Among, the Minister for Lands. And we are discussing the proposed land amendment. So yes, Agnes raised an issue that there is a commission going on, and there's a whole judge doing a job, a good job, I suppose. And that's also a government commission. Why not use that channel to sort some of these problems instead of having two things?
First of all, the commission was appointed by government, yes. Appointed by the president, and so the commission of inquiry has terms of reference. And we know what the commission is supposed to address. The commission's work does not stop government from working. When government identifies an obstacle, government is mandated to continue with its normal day-to-day work, just like we are continuing as a Ministry of Lands with our day-to-day work. So in the circumstance of this amendment, it's not that the amendment came today. The amendment actually was stood over in last parliament with many other amendments in the Constitution. So I want to really assure people that the problem that has been identified cannot wait, because there are many people who are saying, why don't you wait for the commission of for the full amendment of the Constitution? We are saying where we are going. Government has priority, and majority of the priority when we want to deliver the standard gauge railway, it is supposed to be delivered within the next, from the next 2 to 3 years. We are supposed to have started. We need land. We are supposed to do oil pipelines. it requires land and land acquisition. We have roads,
but you see,
electricity.
You know, Peter and Agnes have, actually Agnes set an example of fraudsters, where there are some people who have prior knowledge about government projects, and then speculators, they'll go and buy a stretch of land. You won't even be surprised somebody can buy a narrow stretch because they know exactly where the road is going to pass, and then, you know, of course they buy from maybe willing sellers, but again, because they have some kind of information that everybody doesn't have, and in that itself, there's a lack of integrity from the people who have information, and they use it to enrich themselves.
Now we are having two-pronged approach to that. The first one, now we've come with a policy where once a gazette, because it's the Minister of Lands who gazette a corridor for infrastructure development. So the new guidelines that I have issued, which is now in place, is that once a corridor for infrastructure has been gazetted, there will be another notice to the Commissioner Land Registration, Commissioner Survey and Mapping, to stop and halt transaction in that corridor. So with that, it will only be those who will be in that corridor that then will be, the inventory will be captured for that. So we hope that will address the issue of the speculators. But also, by and large, the reason why this proposal is very vital is that before this particular proposal, which directive which I've given, there are people who could have already acquired this land, and if we leave it the way it is now, like what I saw in Bulisa, where from the all of Oima up to Bulisa, where oil is envisaged, almost titles were there without fraudulently acquired. Now, if such a circumstance, if the current law stands the way it is, where it's supposed to be prior payment, not taking possession, not having that money, that is the tactic that these speculators have been using. And most times, the value that has been determined by the chief government value, it is the correct value. But because of what you are stating as fraudster, people who are speculators, they will hike the price 10 times more than the market value. So with this amendment, what the chief government valuer has valued will be paid to everybody, and if you go to court and court accept a top-up, then government will top up. So we will have a balance in such a way that there will be an independent entity, the judiciary, to look at the claim that you, the fraudster or speculators, will present as a top-up,
okay.
Whether it's legitimate.
Agnes, there's already a law on compulsory acquisition, and we need infrastructure development. And so how would you see government proceed with such projects?
I think it is quite very interesting listening to the minister. Now I'm getting a new feeling, Honorable Minister, with all the due respect, that you're proposing to amend the Constitution to deal with fraudsters, which fraudsters we know where they originate from.
The example.
As an example. Yeah, because,
I gave an example.
Yeah, because if I may ask, the infrastructure that is being done today is the same infrastructure you were referring to right from 1900 to 1965. There has been infrastructure, and any government has been doing infrastructure, and the question still remains, why is it that we are having the issues now? So we are proposing humbly to amend the Constitution to deal with fraudsters. That is quite very unfair.
No, I did not say
because,
that.
No, it is implied.
I made very clear justification why.
It is implied.
Okay.
It is implied because I was about to ask you that of all the cases that you are profiling, we also needed to learn from history. The councils here, you always call it case laws. We need to look at such cases that happened, like the cases that you wish to deal with right now. Secondly, Honorable Minister, like I still insist, we are not going to deal with a problem while we are creating a problem. I think we are being reactionary, which may be true because we are having all these projects around us, and people have pushed you and pushing government in Catch 2022. But shortly after helping government to deal with the problem, the same fraudsters are going to turn it the other way around and are going to use the same clause to defraud the people again.
Okay. Peter, you alluded to the case where somebody gets a title on Milo land or something. How is that happening?
I want to be categorical. I want to state that the minister can go back and check. There is not a single Milo owner who has caused government problems. All the people who are causing problems own freehold title deeds over Milo land. And you ask yourself, how did they get them? Because you cannot get a freehold title deed over Milo land. And this is a problem which the minister should sort out first and foremost before they tamper with our constitution. Secondly, I want to say that there are so many problems which the ministry knows about which should be solved before you change the constitution. Problem number one, go to Lubowa. I read in the papers recently that there is a hospital which is going to be built there. And the president himself was taken there. There's a big dispute about that land. It was stolen from the rightful owners. Now, if this bill goes through, the government will go to the owner and say, we are paying you 10 million shillings, go to court. And the foreign investor will come and take over the land. And we are saying that there must be protection of Ugandans because the intention is to give land to foreigners. That's for sure. Some people in government have stated it clearly that they want to give land to foreigners. And when you come and tell me that you need 100 acres to construct a road, I ask you, why? What kind of road is that? And this is true. Some of the claimants are claiming in respect of 100 acres along Entebbe Road.
How does that come about?
No, but surely, with due respect to my elder, what the purpose, the exception that have been created for land acquisition is very clear under Article 26. Now, for my senior colleague here, not colleague because I'm not a lawyer, to say the amendment is to give land to foreigners is actually to mislead. Article 26 is very clear, Section 2, exception under which compulsory land acquisition is clearly for public purpose, which is public use, public safety, public order, public health, public morality.
But a foreigner can invest in hospital for public health, and that can be that hospital can be foreign owned.
No. You see,
the case of Lubowa, Honorable.
The case of Lubowa is where government has a freehold title. Now, if the
over Milo land?
Yes, there are very many freehold on Milo land. There are very many Milo owners who sold land to government.
But
Peter,
the descendants,
let me give an example. Let me give an example. National Water and Sewage Corporation is it after Mutonyo?
Okay.
Gaba. That was a Milo land, which was sold.
Which belongs to Prince Musa.
Which was sold by the owner.
To government.
There are very many people who sold, their descendants sold land. But now we have third generation descendants who have started claiming afresh. That's another problem that we are having. So let's get case by case. If you are a Milo owner with a case, let me give another example. That Madivani in Kajansi. From 60-something, Madivani has been having a factory in that place for all these years. But somebody has come claiming the land. Literally, the whole of Kampala is being claimed by the descendants of former Milo owners, most of whom have sold. Just 3 months ago, I had a family of Saapolo Kagwa claiming land in the railway land right from behind the railway post office going to Zambia Road. But when I dug up the evidence and showed them, the sale that their descendants sold, they somehow they retreat. So let's take case by case.
So yeah, okay.
Otherwise, if we are to say, if we are to say that
Agnes was right. Don't just pick out one thing, simple thing. I know that technical people in the Ministry of Lands have been misleading their political leaders about those sales the minister is referring to. What happened was that Europeans could not own, and non-Africans could not own Milo land. And to get around that problem, the Africans would sell the land to the governor. Until in 1955, the British government made a declaration that you cannot buy land. It was converted into 99-year leases. Whenever you talk about selling Milo land converting it to freehold, it is because of the 99-year lease, most of which have expired. And when they expire, they are transferred.
So are you saying you can convert into freehold?
No, not now. But then you could, under the law that existed in 1915. But you cannot do it now.
So, and by that time, there are many people who converted, including government. Those
but for 99 years.
And converted. But after the 99, there are conversion into freehold.
No, the law is quite clear. The Crown Lands Ordinance, Section 10, subsection 4, clearly states that at the end of the term, the land reverts to the owner.
It's not yet 99 years since.
It has expired. Most of them have expired, and that's why you have these claims. But instead of these lands being returned to the owners, the descendants of the original owners, people in the land office and elsewhere are selling them to foreigners. We have evidence.
So, but that is not a matter for this debate.
Yes, but
no, it is not. But it is part of the problem that has to be solved.
Which is yes, I agree with you that we solve problems one by one in the context within which they are brought. Now, in this circumstance, we are talking about obstruction to government infrastructure.
And compensation.
You are giving and compensation. The example you gave in the case of Loboa cannot stand. Why? Because in the Loboa case, that is land that government has a freehold. Now, if there are people who want to claim or have a claim, I have seen they have gone to court, then that dispute is to be resolved between government, because now government is the holder of the freehold title, with the claimants. It has nothing to do with compulsory acquisition.
It has, madam.
No, it doesn't.
May I tell you why?
No, for in the context which I am stating why we acquire land compulsorily, it doesn't. Because if court finds that this person was the land belonged to him, it didn't belong to government, then the process of compensation will start the way it is supposed to be done under Article 26.
No, you cannot run government along those lines. I'm sorry.
But
because let me tell you, that land in Loboa stands on plot 101, block 269. When you go to the land office in Mukono, in Wakiso, there is no owner for that land. There is no owner.
And how is that?
We don't know.
But they have gone to
But the government is saying it is their land.
Yes.
And we are saying that you cannot compensate.
So where is the claimant coming from if the records are not there to show the owner?
We don't know.
I think this is how.
Can we go back to the topic?
Yes, we are saying that it is, Madam Minister. We are trying. No, not
where somebody is in court with government. Actually, even under the rule of sub judice, we are not supposed to discuss that matter.
Okay.
No.
I think.
Okay.
So can we discuss the principle of compensation, the topping up?
Compensating who?
The landowner.
The one who has a freehold title deed.
No, the landowner. For us, for example, in the context of of a Milo owner versus a Bibanja holder, we have a formula. A Bibanja holder has a percentage, the land
But-
title
Oh my
holder
God, we have
I
a problem.
I think we are
where
dealing
there
with
are customary ownership, we have a
no,
formula.
Oh no, oh no.
Where there, no,
Okay.
you need to help us. What are we discussing? What are we discussing?
I think I think the minister is so much interested in debating the amendment as they are being proposed.
In
Yes,
isolation.
and I think why we are diverting, if we are diverting anyway to all these details, is the fact that, Honorable Minister, we are saying you may be proposing to deal with a problem that is much complex than what you wish to actually deal with. And I think it is incumbent on government to really not solve a problem in its own favor first without dealing with the complexities of land that are all over the place. Because we have also had cases where you really value the actual value, but the fraudsters that are emerging largely from where you're coming from, Honorable Minister, all around where you're coming from, and I'm not talking about your home area, but I'm talking about the sector you're dealing with, are the people that go to the rightful owners, and instead they are saying, we are giving you less. You understand? And they are taking the difference. So the whole valuing process also sometimes is mad with a lot of fraud and causing people to protest and contest the kind of value that you're giving them. I think your sector and the ministry has to deal with the deeper issues that are surrounding land than symptomatically dealing with the particular issue that we may run and do these projects.
But Honorable Minister, why not take it into the expeditious look into a court case? If somebody is, for example, aggrieved and has gone to court, instead of you taking over, you can say, let court deal with this thing expeditiously, so that, because at the end of the day, court will determine the end result.
Yes, but I've said that
no, but you said you want to continue with the project.
Exactly, because
but that somebody would feel aggrieved. That would be unfair.
No,
you can say there should be expeditious
you want
process.
to feel aggrieved. Why? I explained earlier that in compulsory acquisition is already existing. Therefore, at the point where we are disagreeing on the value, you would have already given the land. You have no problem with giving the land. Your only problem is on the price, the value. So whether I use your land or not is not a problem. We are only disagreeing on value. And me, I'm saying, since whatever the case, I will still use your land. Let me use it while we resolve the matter in court. But also I'm saying, Parliament, give me a timeline. If you think the timeline for me to resolve the matter with the landowner is 1 month, give me. If it is 2 months, give me.
And
so
I am,
let me finish. Not case by case. I have already stated
but
the law is not
but those are saying
once it's enacted
that that compensation should be fair, should be adequate,
and should be prompt.
Should be prompt.
Exactly.
Yeah. So
and according to the law, for us, we have a methodology of arriving at fair, adequate compensation.
yeah, but if somebody is challenging the fairness of that,
that is why I am saying.
So they are
That's
challenging
why
the
I-
formula.
court should expeditiously deal with that issue.
That's
then you
okay.
can have the land.
What I am saying is that I have a duty and a timeline to deliver public good. And therefore, since the disagreement is not whether or not I will take the land, the disagreement is only on the value. It doesn't cause any harm for me to take possession, work on what I want to deliver to the people, but at the same time allow you to go to court and determine a top-up. Meanwhile, what I feel is fair and adequate is paid to you. Claim the top-up within 1 month, 2 months, whatever Parliament give me will be paid to you.
Fair should be. Yes, Peter.
And I already said that under the guideline which we have issued, a chief government valuer is supposed to return a value that has been accepted by a minimum of 70%. So by the time 70% out of 100 have accepted a value, it means that that is a fair value. So 30% in all fairness, in democracy, would allow me to take possession, deliver public good, which will serve you also
Okay.
the 30%.
I think
While I am not
very
refusing
briefly.
to talk for you.
Very
briefly,
briefly, I
Senior
once
Counsel.
warned the minister that the government is there on behalf of the people. And arrogance of power is a very dangerous thing. What I see here is arrogance of power. I'm going to give you 70% of the value of your property because I feel it is
No,
what
no,
you
no, no.
have.
I said
I'm
70%
saying-
of people have
I'm
consented.
saying as long as there are people who are saying that they are also entitled to their value, you have not solved the problem. Secondly, I want to suggest that if it is a simple question about value, why don't you amend the Act itself and not the Constitution?
Because the provision that gave me that power, in the wisdom of the Constitutional Court and Supreme Court in 2014, they expunged that principle, which is Section 7 of the Land
They did
Acquisition
what they
Act.
say.
So I cannot cure it under the Land Act. They will still say, because the Constitution 26 says prior payment before possession. So if I say I cure it in that
And you are
law,
saying post-payment.
in that law, then I will still be rendered unconstitutional.
Okay.
That is the
This is what
reason
we're
why
going to do.
I have to bring it here.
Okay, we're going to take a break. When we come back, I'll open the line so that you too can be a part of this discussion. You can pick your phone and call us. The numbers will be on the screen, and tell us what you think about the constitutional amendments that are being proposed. We'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara, and my guests tonight are Senior Counsel Peter Mulira, Vice Chairperson of the Uganda Land Alliance, Agnes Kirabo, and Honorable Bet Among, the Minister for Lands. And we are discussing the proposed land amendments in the Constitution. You know, the element of fair, adequate, and prompt, I think.
Prompt, yes.
Prompt compensation is key. But if somebody is still disputing the element of fairness, and then you go and say, I'm giving you that, let us continue, then you are actually imposing yourself on somebody's private land, even though you're government.
No, I'm not, because fairness, the way we are saying, the fairness you are contesting be resolved by court, because me, I'm already telling you, I would have gone through elaborate procedure, which involves the district land board, the local market value. We even involve obtaining sales agreement of the most current land sales in order to arrive at a value.
Yes.
So,
but still,
and I told you
if that's
that
what is contested,
yes,
somebody
you
would feel
see,
it's not fair.
that's why I'm
and the last
saying, no,
arbitrator is the court.
Yes, that's why I'm
So
saying
why don't
fairness.
you deal with the court expeditiously?
That one we have already agreed. I've already said under this proposal, we said deal with it expeditiously. Parliament give me what is expeditious dealing with the matter. But at the same time, I'm telling you, how do we determine fairness? For me, if I go in an area and I say this land is 10 million, and out of 10 people, 7 people tells me that I agree, and 3 people tells me I don't agree, I am going to take 7 people as the standard of proof of fairness. And I will tell you that price that 7 people out of 10 have said is fair, I will pay all the 10 of you. However, the 3 of you who disagree, I cannot subjugate your right. You go to the next level of court. When court says stop, then I will stop.
Okay, Peter.
Well, the courts have no ability to decide which is the fair price. And for this reason, I want to suggest an alternative. If the government makes an offer, it must be based on evaluation by a professional person, in this case a government valuer. And if Peter Mulira is the one owning the land, he must also produce a professional valuation so that it is not a figure coming out of the head of Peter Mulira. It must be a valuation by a professional valuer as against the government valuer's valuation.
So there should be 2 valuers.
2 valuers. And if the 2 valuers disagree then you refer the matter to arbitration. That will solve the problem immediately. But what is happening now, because of these speculators, the government valuer comes with a valuation, say 100 million, and Peter Mlila comes with a figure of 20 billion, without producing any supporting evidence. What I want to suggest to the minister, that as a way forward, let us insist that for one to oppose the government valuer's assessment, he must produce a professional valuer's value to compare with the government valuers. And if the two disagree, then you can go to arbitration.
But that will bring in more delays, which
No.
the government wants to avoid.
But for me, I'm also thinking that we may not even walk up to arbitration, because there is not going to be a need for that. If there are standards and there are formulas for for valuing, I think we just need to deal with that standard first. And then secondly, I think, Honorable Minister, let us agree that among the things that were not supposed to relate to the market to determine prices was land in this country. And I think we are capable, as a government, as a state, to run after that. We also know that we have failed to actually know, when I'm doing the transfers, you would realize that government actually is taxing me on a much lower value of the land, all according to their values, compared to what every Tom, Dick, Sarah, and Agnes is selling on the market. I think we need to learn and deal with that. We need to know by standard in this country, go and hang, but we have standards of value of land in this country based on the levels of development. That's one. Two, the various items that are being valued. I'm working with communities, and communities actually know that a mango has been valued before even there is any compensation or anything that is going on, because these values, according to your law, are set by
district land
yes,
board.
by the district land boards. So people know the value of a bean, they know the value of a mango, and whatever that is being valued. So why don't we make the values standard annually? We better invest in that. And the people know, actually, you're going to deal with the speculators, because it is going to be known. Land in this particular place, a rock or a river, if it is compensated for, a bean and what is at this place. So where is the contestation going to come from? Let us deal with the system.
Okay, let me open the line so that we get to know what Ugandans are thinking tonight about these land amendment proposals that we have, constitutional amendment proposals that we have. Maybe you can ask the minister, or you can tell us, give us an idea of how we can deal with this, have infrastructure development without delay, but also have fair, adequate, and prompt compensation to the owners of the land. I'm taking the very first caller online. Hello.
Thank you, Kamara.
Hello.
Thank you, Kamara.
Good evening, sir. Let me ask my producer to turn up the volume a little bit here so that my guests can hear you, and then you can continue speaking, sir. Okay, what's your name and where are you calling from?
I'm called Engineer Raymond.
Raymond.
Yes, I'm from Tinda.
Okay.
Thank you for a good topic.
I'm unable to hear you, Raymond, very well, and so are my guests, so I don't know how to deal with that.
No, you can get me well?
No, I can't. Okay. It's bringing in an echo into the studio. Okay, unfortunately there was a problem there. I could not hear Raymond very well, but if you can call again, that will be okay. Let me try to maybe take another caller online, and then we'll get to know what you have to say tonight. Hello? Hello? I think I have an issues with my lines. Anyway.
Maybe I answer. I think I want to agree with what she has stated, which we have already started working on. We have started working on research and assessment of compensation value on land and property, and we are trying to categorize rural land, peri-urban land, urban land, municipal land, and city land, and attach value to land. However, what will be a problem will be the attaching value on property, because property of course, you find semi-permanent, you find permanent. The same material, a person in rural area, maybe even a person in rural area will claim they use more money to purchase cement than a person in a city. So on the value on land, we are already collecting that, and we are going to standardize and give value on an annual basis for land. It will only be property that maybe will be under contest, and we are also working with the district land board to build their capacity, because some district land boards who are supposed to also give annual value are not giving annual value. Sometimes they give a value which takes 3 years. So it's a good point that I think is important.
But I think what she was meaning, you can start with that before you even get into...
That's why I said I've already started with it, and we're already doing that one.
But also government does constructions, and everyone does construction. And we know that I highly doubt that there is a particular person who has imported a bag of cement at 100,000 in this market for his or a particular form of construction. So even these can be valued.
Yes,
and the
they are
values
valued,
become,
of course.
yes, and the values become standard, and then we call it quit.
Okay, let me try also to maybe I can establish the lines to the viewers now. Maybe they are right better now. Let me take another call online. Hello. Hello.
Yeah, the problem.
Okay.
Hello?
Yes. Good evening. What's your name and where are you calling from?
Hello?
Yes. Let me ask my producer, please. Could you turn up the volume in here so that my guests can hear the call online? Hello.
Yeah, yes, I'm under Maricha.
Oh, God.
No. Unfortunately, your voice is so faint in here. Hello.
Yes.
Yes, we can now hear you loud and clear. What's your name and where are you calling from?
I am under Maricha. I'm calling from Mutungo.
From Mutungo, under Maricha.
Yes.
Okay, go right ahead, sir.
Yes. Yes. Can you hear me?
Yes, loud and clear.
Yes. Yeah. I'm thanking you. I'm thanking you, Mr. Patrick.
Thank you.
And there. Yeah.
Could you go right ahead, sir, with your contribution, without stopping?
Yes. Actually, this issue of constitutional amendment is okay. I must thank Mzee and this lady in the middle and the minister for deliberating on these issues. This issue of compensation is really critical, and we have issues in Arua. I don't know whether this Arua appeal. There are a lot of complaints there. Actually, I am following up this issue. The issue of standardizing is still critical, and these issues must really be addressed. And not only basing on the issues of amendment law, we must institute standards in valuing land and compensation. Arua airfield issue is another area of contention there, of serious contention. This is to the attention of the minister. The spokesperson for IU Chiefdom, actually, very soon I'll be in her office.
Okay.
Thank you.
Okay, thank you very much for your contribution. Let me try, but if the line is not as good, probably we want to go that route. We'll have to, unfortunately, not to take all the lines because of they don't sound clear tonight. I'm going to try to take another call online. Hello. 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 Okay. If you could to Andama with the problems in Arua.
I think he makes similar points. That number one, the issue of compensation is critical, and what he proposes is that beyond the amendment, we need standardization. But let me also state that we have really a clear methodology. And by the way, what you're proposing in respect to having a private valuer, what we had done to try and come up with a fair compensation, we have been asking all the projects, UNRWA, whichever government project, to get private consultants who determine the value of land. Then the chief government valuer gives assessment methodology to the private consultant. And then the chief government valuer provides technical people to supervise the private consultant to see whether they are following the methodology. Then when their work is concluded, the chief government valuer then goes through to
If I may ask,
scrutinize
who pays the private consultant?
and authenticate. It's still the government.
So you have
Yes.
a government valuer and a private consultant, all of them working on the same project.
No. What I am saying, for example, you have standard gauge railway. Let me give an example. A project starting right from the border, Malaba, up to the other border of the corner of Uganda. So what we have been doing, because the chief government valuer's office cannot have all the requisite staff for all the government projects. So we said, to address the matter, let us give the methodology, the standard guidelines of arriving at the value of compensation. Each of you, UNRWA, the standard gauge railway, Uganda electricity distribution and all that, National Water and Sewage, use a private consultant, but these are the standard methodology. Then we attach one of our staff or two, depending on the volume of the work, and these people will then be assessing whether or not the private consultant valuer is following the guideline. Then they file a report to the office of the chief government valuer, who then scrutinizes to ensure that the private consultant has used the standard methodology. And if found to be the value to be okay, then that is when the chief government valuer will then
Senior counsel, fair
authorize.
enough.
So therefore, we have already been using private consultants and arriving at a value. Therefore, I do not know how this proposal would then improve that. How would it?
How would it deal with the fraudsters?
Okay, Peter.
We have to remember that this problem is new. The Land Acquisition Act has been in force, as the minister says, since 1903. And we didn't have these problems. It was working very well. The problem started during the last 4 years. And why? It is because of fraudsters, speculators, and frauds in the land office. If we can deal with those facts, we can solve the problem. But you cannot solve the problem by just going to Parliament and amend the Constitution when you have not removed the spectre of fraudsters and speculators from your scene. So my proposal is this, and I don't know why the minister did not take it seriously. The government valuer is a professional valuer, and he knows his methodology. You cannot give him anything which is outside his professional work. I am saying that if Peter Mulira is to reject the government valuer's report, he must produce a report by a private valuer which contradicts the government valuer's report.
So Peter Mulira will pay for that private value?
Yes, he pays for it.
So you are assuming a peasant who only has land somewhere can afford to pay a private
No,
valuer?
I told you this. Not a single customary tenant, not a single mile owner landlord has ever caused the government problem. The problem is coming from fraudsters and speculators. And the government has refused
So
to
the assumption
do.
the problem is caused by people who have the money.
I want the
And they have the
minister.
information
I
and they
want-
are well
But that may
placed.
not be the case
Yes,
throughout.
I want the minister to produce one single mile owner who has obstructed government of projects. Not a single one.
No.
Not a single customary owner. The people who are asking billions of shillings are all people who are speculators or who have bought the land from mile owners for purposes of speculating.
So,
And
so the whole thing is that whereas the proposal could be good, but what I'm hearing from Agnes and Peter is that
No, I want to
clean up the house first.
First, I want
Clean
to
up the house first.
produce the evidence here of the Milo owners. I will give you and the senior council private Milo. This is Kampala Northern Bypass, Luanga Edith, Bukoto, private Milo, rejected the amount given. Kampala Northern Bypass, Katabazi Joshua, Chebando.
You will find that behind Katabazi Joshua is a speculator.
So I see somebody here claiming 1.5 billion on a road to Entebbe Express Highway. I'm wondering
why?
What kind of how much land you want?
And Katabazi is a stand-in for the actual.
And even leasehold owners. So
what the information we are giving you
yes,
is that you can mention Katabazi's name. In another forum, I've made a distinction between a landlord, a Milo landlord, and a Milo owner. A Milo owner is a person who goes and finds Katabazi and gives him 10 million shillings, and Katabazi is happy. He applies to the speculator, goes and asks 1.5 billion shillings. And I cannot take that list as being...
Okay, so what we can agree on first as a principle is that for me, according to my information, I have all categories of people and land tenure system that have made claims, both private, leasehold, freehold, and in some circumstances, I told you, in my own constituency, where the Karuma hydropower project is, there are people who have rejected where it's customary ownership. So surely the problem...
After people bought from Kampala went and bought.
Yes, I agree with you.
If we are to parade them, there are certain characteristics that are common among all of these people. But I also wish to inform Ugandans that, dear Ugandans, the Physical Planning Act 2010 declared the whole country Uganda a planning zone. That's principle number 1. 2, the minister has promised us that there are standards of compensation and valuing of our property and land. So please don't defraud the country and cause the whole country play around with our constitution. 3, Honorable Minister, where are the national land use plans and national land use maps, such that everyone gets to know that I'm buying this place, but government, I don't know how many 100 years or so, here there is going to be, you know, there are certain infrastructures that are standard that we just don't wake up in the night and we start them. They are known. 3, when our government institutions also have master plans beyond the strategic plan or the national development plans of 5 years. And then we know that our country water infrastructure 50, 100 years to come is going to look like this, and we plan for it.
Vision 2040. But anyway, our time is almost out. They should be embedded in something like that.
Exactly.
Yes. But our time is out. Let me begin with you, Senior Counsel, to give us your parting shot on the show tonight.
My parting shot is that the minister should not go ahead with amending the Constitution. She had heard our views. Let her go and think about them. These are views which are held by so many Ugandans. And 2, that bill does not stand a chance of being upheld by a court of law. It will be unconstitutional because it infects a lot of provisions of the Constitution.
So you are saying that somebody could actually go
the minute the Parliament passes it into law, we are going to go to court to challenge it.
Okay, Agnes, your parting shot.
I think, dear viewers, this evening, you have seen how far, wide and deep corruption has taken us into this country. And I know the fraudsters are out there watching us. Please do us a favor. But we are also asking government that actually, having understood the problem we are dealing with this evening, let us stay this bill. Let us go back to the commission, because the commission was supposed to deal with land grabbers. And actually, Honorable Minister, the bill you're proposing to amend our constitution is nothing but to deal with grabbers that do not only grab land, but they have also come to grab and defraud the country and the state. And we are not going to play around with our constitution just to deal with thieves that have been created in less than a decade in this country.
All right. In fact, some people are calling it the Betty Among bill.
Thank you.
The Among bill.
Thank you very much. I want to thank the two comrades for actually, first of all, coming to the position that we are now dealing with the issue of people who genuinely obstruct government projects. In the 5-year program of government, we are supposed, the same Ugandans have tasked us to deliver on standard gauge railway. You are the same Ugandans asking government to deliver electricity to your doorstep. You are the same Ugandans asking government to give you water, asking government to give you roads. It is not government that is forcing you to have the public good. That request and demand you have from government cannot be delivered without this bill. I urge you to support this bill so that we can deliver for you the public good. It has nothing to do with land grabbing.
Honorable Minister, thank you very much. Honorable Betty Among, thank you very much.
Can I give you proof? Can I give
And I want to conclude by saying
Yes.
it will never be unconstitutional. Okay. Why? The Constitution gives provision for amendment. Article 26 gives exception for compulsory acquisition, and when we amend that particular provision within the precepts of how we amend the law, it cannot be unconstitutional.
Thank you very much. Senior Counsel Peter Mulila, thank you very much. Agnes Kirabo, thank you. Honorable Betty, we appreciate your insights on this issue, and I suppose the debate is going to continue on this issue because Uganda's land question is quite a big one and has not been resolved for a long time. But how I wish we could agree on some of these issues so that we can have the infrastructure, but also feel some kind of fairness in the compensation and compulsory acquisition of people's land. Good night and God bless you.